Hi and Assalamualaikum warahmatullahi wabarakatuh. Welcome back to our talk show for this week. As usual, I'm your moderator, Badr Shah Abdullah, and today we are going to discuss on a very special topic, which is legal framework and Shariah issues in Mudarabah. And we have invited a very special speaker from Legal Aid Department Malaysia, which is Sister Siti Nabila Tasha binti Zahari. So without further ado, let's get started with the introductions of the topic. For the introduction, we're going to look what is Mudarabah is all about. Mudarabah is actually a contract between a capital provider, Robul Mal, and entrepreneur Mudarib, under which the Robul Mal provides the capital to be managed by the Mudarib, and any profit generated from the capital is shared between the Robul Mal and the Mudarib according to mutually agreed profit sharing ratio or PSR, where the financial losses are borne by the Robul Mal provided that such losses are not due to the Mudarib's misconduct or ta'di, negligence, taksir, or breach of specified terms mukallaf assured. Now we're going to look into the definition, nature, and the concept that are going to be explained by Sister Tasha.
Thank you, Brother Badrul, for the brief explanation just now. So I will explain more on the Mudarabah nature. Mudarabah is a contract based on a fiduciary relationship, akad al-amanah. Under this principle, a mudarib manages the Mudarabah asset in trust and is not liable for the impairment of the asset, except for impairment which is a result of the mudarib misconduct, negligence, or breach of specific terms. Mudarabah has the right to terminate contract unilaterally, except in three conditions. First, which are the Mudarib has commenced the work relating to the management of the capital of the Rabul Mal. Second, the contracting parties have agreed to enter into a Mudarabah contract for a specific time. And thirdly, the contracting parties have agreed not to terminate the Mudarabah on this Mudarabah contract within a specific time. Mudarabah is categorized into two types, which are unrestricted Mudarabah. Unrestricted Mudarabah is a contract in which the Rabul Mal permits the Mudarib to manage the Mudarabah capital without any specific restriction. The second type, which is a restricted Mudarabah, is a contract in which the Rabul Mal impose specific restriction on the Mudarabah terms. The Rabul Mal may specify conditions restricting the Mudarib, such as the determination of location, period for investment, type of project, and commingling of funds. So, Brother Badru, you mentioned just now that you have background on the contract of Mudarabah. So, can I know what is the legal requirement of the Mudarabah contract?
Thank you, Sister Tasha. So, for the legal requirement based on Bank Negara Malaysia, as you can see on the screen, the purpose of this policy document is actually as denotes a standard requirement or specification that must be complied with. Failure to comply may result in one or more enforcement actions. G denotes guidance, which consists information, advice, or recommendation intended to promote common understanding and sound industry practices which are encouraged to be adopted. Islamic Financial Institution, or IFI, actually means first, a licensed Islamic bank under FSA. Second, a licensed Takaf operator under FSA. C, a licensed bank and licensed investment bank under FSA approved under Section 15, bracket 1, bracket A of the FSA to carry on Islamic banking business. And the last one, a prescribed institution under DFIA approved under Section 129, bracket 1 of the DFIA to carry on Islamic banking business or Islamic financial institution. Now we move to Sister Tasha to explain further on the Sharia requirements.
Thank you, Brother Bud, for the question. So I may proceed with the Sharia requirement on the Mudarabah. So basically, the goal of Sharia standard is to establish a set of guidelines for Sharia contract that can be used in Islamic financial operation. The document make it easier to comprehend a specific Sharia contract obligation. There are 5 components involved in Mudarabah for it to fulfill the Sharia requirement, which are the first one, the contracting parties. The contracting parties in the Mudarabah are Rabul Mal and Mudarib. Both Rabul Mal and Mudarib must be a natural person or legal entity who shall have legal capacity to enter into the Mudarabah contract, including the capacity to perform agency contract, either as a principal or as an agent. There must be offer and acceptance involved between Mudarib and Rabul Mal in order to execute the Mudarabah contract itself. Second element on the management of the Mudarabah. A Mudarib shall have the right to manage a Mudarabah venture. The Mudarib is responsible to ensure the proper management of the Mudarabah venture and acts in the interest of the Rabbul Mal. The Mudarib's mandate shall be provided under the terms and conditions of the contract. The element on the capital. So the capital of the Mudarabah shall be provided by the Rabbul Mal and managed by the Mudarib. The capital shall be identifiable, readily available and accessible for the Mudarib to commence business activities. The capital may be in the form of cash or including intangible assets. For element on the profit element, Mudarabah profit is the value created over and above the capital, which is determined based on a methodology acceptable by market conventions or practice. A Mudarib shall not guarantee any profit. A Rabbul Mal and a Mudarib shall share profit based on a ratio mutually agreed between them. The last element on the loss shall be borne by a Rabbul Mal up to the capital value. A Mudarib shall not be liable for any impairment of asset unless such loss is due to the Mudarib misconduct, negligence or breach of specific terms of the contract. In the case of any loss, the Mudarib shall furnish the reason for the occurrence of the loss. Brother, so may I know that is there any operational requirement needed for the Mudarabah contract?
Thank you, Sis Tasha, for your detailed explanation on Sharia requirement. Now we move to the operational requirement. The first one, to guarantee that Mudarabah projects are run in accordance with Sharia rules, the IFI will establish a sound governance and supervision framework. The second one, the IFI will ensure that the Mudarabah endeavor is structured, implemented in accordance with detailed policies, procedures, processes, suitable infrastructure, and thorough documentation. The third one, the IFI will ensure that the Mudarabah business is properly structured, including undertaking an end-to-end process to match risk and reward profiles between sources and use of funds. Next is to effectively manage risk throughout the life cycle of Mudarabah projects. The IFI will institute and implement a strong and integrated risk management system. Next, to help stakeholders understand and analyze Mudarabah ventures, the IFI will provide proper information and opinions. And the last one, to protect the interests of stakeholders, the IFI will conduct Mudarabah projects in a fair and transparent manner in accordance with the Sharia. Now we move to the next one, which is the operation and application in the FI by Sister Tasha.
Thank you for the questions. There are 4 operations under the Mudarabah. First operation on the arrangement for the guarantee. Mudarib shall not guarantee the capital or the profit. They have certain measures need to exercise, which are Rabbul Mal may take a collateral from the Mudarib, provided that the collateral could only be liquidated in the event of misconduct or negligence or breach of terms of a contract by the Mudarib or the Rabbul Mal. May require the Mudarib to arrange for an independent third-party guarantee. Second, arrangement of a Mudarabah with a Wadi'ah. Wakalah or musyarakah contracting parties may agree to an arrangement whereby certain amount of fund is assigned as a Mudarabah capital and another portion of the fund is assigned under Wadi'ah, Wakalah or musyarakah contracts. Third operation, which on the arrangement of a Mudarabah with a Hibah. A Mudarib may provide a hibah to a Rabbul Mal. Provision of a hibah shall observe the condition, which are the hibah shall not be sourced from the capital or the Rabbul Mal's profit or portion. The provision of the hibah shall not amount to a guarantee of capital or profit by the Mudarib. Fourth operation on the arrangement of Mudarabah with a promise. 1. A Mudarabah contract may be arranged with a promise where a Mudarib undertakes to purchase a Mudarabah asset upon the occurrence of a specific event as stipulated in the Mudarabah contract, or an agent or wakil appointed by a Mudarib undertakes to purchase a Mudarabah asset upon the occurrence of a specific event as stipulated in the Mudarabah contract. Simple partnership, investment account, project financing, Mudarabah financing in service sector and others type of financing are the example of application we practice in finance using Mudarabah contract. However, there are some difference in real practice with the contract itself. Do you know why this thing happened? Can Brother Badrul explain to us?
Thank you, Sister Shah, for the insightful explanation. Now we move to the gap analysis. B&M developed a product through a stand-alone platform with minimal engagement from the bank and the platform acting as a direct link between investor through equity fund and business via entrepreneurs as a partners. This platform is a core investment account platform IAP which was established in 2015. So the intentions of IAP is to link the retail or corporate investors directly with the companies seeking funding for their businesses. IAP also represents the contractual relationship between the investors and Islamic banks. In this scheme, the investor can specify where funds are channeled or lead to, for example, choice of underlying ventures to invest in, and define investment mandate and eligibility criteria for the financing, for example, investment tenure and type of industry to Islamic banks. Any returns on IAP are based on the performance of underlying ventures. Since it is a PLS scheme, funds placed under IAP are not guaranteed by the deposit insurance corporations. Next, the use of Mudarabah contracts to facilitate takaful in contracts appear to distort takaful actual purpose, which are to provide mutual protections for fund members. The Mudarabah model was launched with the formations of Takaful Malaysia in 1984. Under Mudarabah Takaful model initiated by the Takaful Malaysia, the Takaful operator is appointed as a manager to manage the Takaful funds on the behalf of the participants as a Mudari. The participant provide the contribution which are pooled into the Takaful fund and are considered as Robul Mal. The Zakaful operator manage the payments of the claims of a coverage to participants and investment of the Zakaful funds. I think that is from the gap analysis. Now we move to Sister Sasha for to conclude our discussion today.
To conclude the overall topic of this talk show, Mudarabah is solely Shariah-based transaction. However, full potential Mudarabah technique of financing not yet been realized. It is understood that various obstacles and hindrances have impeded the successful implementation of profit-loss sharing contracts in general and Mudarabah in particular. In addition to this, practicing Mudarabah is more difficult compared to Musyarakah and so on, since in Mudarabah bank does not have any involvement in the venture and the management will be left solely to the Mudarib. Consequently, high confidence on the ability of the Mudarib to manage the business is extremely needed. So I think that's all from me, and I hope this sharing will help you to get more input on this topic. So thank you.